So another big switch. We're going to talk about work-life balance and the facts of life. Leading off on this topic is Vladeck with a response from Betsy Plevan.
As work environments and workforces change, so do the laws that govern the relationships between employers and employees. We have come a long way from the 1970s when the Supreme Court said, and this is true, that pregnancy discrimination is not sex discrimination. Okay? Well, we now have laws, federal, state, and local, that make it clear that employees are to be judged on their merit, treated according to their abilities, and not disadvantaged because they are pregnant, have small children, elderly parents, or others who are close to them who need their care. While we are all now operating at the speed of light, 24/7, there has to be a balance between work obligations and life obligations. Achieving that is an enormous, but when successful, and a rewarding task. To the extent an employee is pregnant or disabled, they are protected from discrimination through various laws, including Title VII, the ADA, which is the Americans with Disabilities Act, and the Family and Medical Leave Act, and state and local laws. An employee who has, for example, a spouse or a child with a disability is covered under the ADA, which prohibits discrimination based on an employee's association with an individual with a disability. The Rehabilitation Act provides that protection to federal employees. Where the law is developing, and to be fair, it is not treated in the same way in every jurisdiction, is for those employees with dependent children or caregivers generally. We live in what is called the sandwich generation, in the middle of responsibility for elderly parents and young children. The cases that deal with mothers with young children who are disadvantaged at work are called sex plus cases, or ones where employees are referred to as having hit the maternal wall. Most of these cases are a result of stereotyping by employers. Stereotype notions run the gamut from, if she has young children and is working hard at work, she can't be a good mother. I don't want somebody here who's not a good mother. 2, she can't be a good employee when she needs time to focus on her child. What can happen is that a woman with small children is passed over for promotion because the employer assumes she won't want additional responsibilities or won't be willing to travel. Motherhood can be viewed as a lack of commitment to the job. If decisions are made based on stereotypes, women and men can have claims under the anti-discrimination statutes because they are entitled to be evaluated as individuals rather than artificial perceptions of what their conduct might be because they are members of a group. Employers need to realize that women who have children don't get stupid and don't lose the commitment to the job. How do we, you, avoid lawsuits? Work together to achieve the balance necessary to get the job done, but let the employee deal with life issues as well. Despite what some may think, caregiving and work are not incompatible. Studies have shown that flexible workplace policies actually improve productivity, morale, and can reduce costs, including the cost of a lawsuit. Many companies have flex time, telecommuting. If you have that available to employees, don't hold back because you question their commitment. Don't hold back because you wonder if they're typing with a baby in their lap. Don't assume that an employee will not come back to work after a maternity leave or adoption of a child. Yes, some don't, but most do. And what is critical is that if you make assumptions and are wrong, the employment relationship can spiral into an adversarial one. And make sure the managers get the message. Don't be in court defending the comment, which is true from a case. She won't show the same level of commitment now that she has those little ones at home. Provide reasonable personal or sick days to allow employees to care for themselves and others. Sometimes you have to be creative. The key is that if you have an employee, I feel Cynthia, right? Sometimes, I'm going to be the Federal Express commercial, sometimes you have to be creative. The key is that if you have an employee who has performed well, don't assume that he or she will fail because of obligations elsewhere. Employees have a job to do, whatever else life brings them, but workers can be productive with reasonable accommodations. We all have the potential need. A spouse, a parent, a child could need dialysis, chemotherapy, or some other medical treatment. You may need to accompany them to treatment. That is no reason to lose your job. When you put all the laws together and sprinkle in some fairness, you can have a work environment that actually works for everyone.
Thanks, Anne. I'm sure we don't have a strong disagreement with that very
well,
much,
yes, far be it from me to create controversy by attacking motherhood and all of those good topics. So instead, I'm going to attack the EEOC because I think that this is a really great example of the government going amok. Because there's a big difference between policy and law, and all of you know what's good policy, and a lot of the things that Anne has said certainly are good policies if you want to have a good workplace for people you care about. But there is absolutely nothing in Title VII that says that caregivers are a protected category. And yet we have the EEOC making pronouncements, issuing guidelines, litigating cases that deal with caregivers as
our tax dollars at work.
Right, yes, exactly. And I have other arguments with them too. But so we do have to distinguish, certainly us lawyers, between what's the law and what's good policy. And that's where, that I would like to just emphasize, because again, it's good to do a lot of these things, and it is important to try to prevent claims by having those kind of good policies. But it's also important for those on the other side to remember what's really required and when you do need legislation. Now, I wish I could convince the EEOC of that. I think one of the questions that was raised is, are we going to see a lot of litigation in this area? And I think the jury's out on that. The EEOC, as I said, is still trying, is certainly trying to encourage people to bring these claims. I'm not sure the claims, are very valuable claims, because people don't often get fired for these reasons. But I have had, at least, there are some cases reported, and it is something that I think you do have to be concerned about and sensitive to because of the government's attitude, despite the absence of legislation. And I had a case a few years ago. Fortunately, we won the case, but we went through the court, summary judgment, appellate court, where all that happened was that an employee who had been out on an extended maternity leave because of medical problems. The company did all the right things, gave her more time, etc. And when she's chatting with her male former colleagues, or colleagues who are back at the office still, about her superiors, about whether she should come back to work, they said, well, are you sure you want to do this? This is a really stressful job, and you moved out to, somewhere in New Jersey, and it's a long commute. And that was it. That was the claim, was based on those conversations. These are people who were her friends and colleagues. So there are risks out there, and even though you might be successful in defending the claims, it's a good idea to, you know, to have the kind of attitude that Anne suggested to try to minimize that from happening.
So what do y'all think about the female judge who threw out the sex discrimination against Bloomberg by saying, among other things, work-life choices are choices and you make them?
I'm going to go back to Betsy.
We don't want to attack any judges, so.
Sure. But.
Just to be clear, while there is no statute that says caregiver is a protected category, there is no statute that says sexual harassment is unlawful. That has developed because it's treatment based on sex. What is at issue with many of these caregiving cases goes back to the Supreme Court in Hopkins versus Price Waterhouse, which says don't stereotype people. Stereotyping people based on sex is unlawful. So if men with little children are considered fabulous employees because, you know, they're not going to go astray or whatever, but women with small children are not committed, that's sex discrimination. So I happen to agree that sometimes the EEOC does things that are not necessarily pursuant to any particular statute, but I think that it is incorrect in some ways to say that there is no law, it's really policy.